progress.
Namaste and greetings. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti Anusandhan Sansthan, Nai Delhi, extend my warmest welcome to you all to IMPRI #PolicyLearning. Today, we are gathered here, day 2 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research training course, and internship program. This program is organized by IMPRI, Impact and Policy Research Institute in New Delhi. The chair for the program is Professor Vibhuti Patel, visiting IMPRI, and the fellowship lead advisor and the expert legal hands-on sessions is Dr. Shalu Nigam, visiting senior fellow IMPRI. The distinguished experts include Shri Sindhi Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Vahida Nainar, Professor Mukul Mashay, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Shri Malvinder Singh Baswan, Dr. Purnima Chauhan, Advocate Dr. Albertina Almada, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey Ginello, Dr. Kaustuv K. Bandyopadhyay, Advocate Mrinalini Deshmukh, Professor Sharmila Guge, Advocate Flavia Ines, Dr. Lakshmi Singh, Deva Vidya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumya Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikender Singh Parmar, Shri Shailesh Gandhi, Dr. Simi Mehta, Advocate Dr. Hafiz Gandhi, Professor Amita Singh, Dr. Ajay Gurudavarti, Shri Amit Dubey, Professor Sangam Mitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita, Shri Surendra Nath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for your time, energy, and efforts in truly understanding the vital role and complex intricacies of legal and public policy frameworks. The course will enable the participants to comprehend the nuances and technicalities of legal and public policy paradigms and therefore acquire theoretical insights along technical skills to conduct research. We have also shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session that's learning at your pace and pace. Before we start today's session, I would like to announce the house rules. First, it is imperative that you join the meeting on time. Second, there will be a Q&A session after each presentation. Share your questions in the Q&A box and not in the chat box. Fourth, questions must not be posted as an anonymous attendee. Fifth, ensure that your questions are precise. Sixth, refrain from making general comments in the questions to save time. A session for day 2 with the topics of multiple legal perspectives by Advocate Dr. Shalu Nigam and international human rights by Advocate Dr. Vahida Nainar. To start the session, we invite Professor Vibhuti Patel for her opening remarks. Professor Vibhuti, over to you.
Yes, thank you, Shweta, and esteemed panelists, today's panelists, Dr. Vahida Nainar and Dr. Shalu Nigam. I would first of all offer my thanks to Dr. Arjun Singh, Dr. Simi Mehta, Dr. Shalu Nigam, Dr. Shweta Shankar, Ms. Vidhita, and Mr. Satyam Tripathi and Shweta for their hard work. Today we are on day 2, and welcome to this second day of the online National Summer School program. It's a 2-month online immersive legal awareness and action research certificate training course and internship program. Let me share with you the recap of what transpired in day 1 in the inaugural session. Ms. Shweta Shankar explained the vision, mission, goals, and objectives of the course as she did today also. And Dr. Simi Mehta, she provided an overarching perspective of the course content. Mr. Sandeep Chachra, he in his lucid commentary dwelled upon progressive and regressive public policies and its subsets, which are laws. He averred that practitioners rooted in the ground put forward perspective to advance the interest of marginalized and contribute towards formulation of laws that advance agency of the marginalized. That means those who carry burden of exploitation, oppression, and injustice. He also said that fundamental tenets of public policy, which are equality, liberty, and freedom, for which we need substantive legitimacy and procedural legitimacy. Public policies need to be based on data, evidences, social knowledge, social and environmental cost-benefit analysis, and people's participation. He cautioned the participants about the democratic majoritarianism as against authentic participatory democracy that is responsive to numeric, ethnic, religious, sexual, and gender minorities. He also mentioned growing inequality and rise of identity politics, nativism, chauvinistic regionalism, and role of human rights defenders. He gave illuminating account of solidarity struggles that happened for the farmers' rights against the 3 draconian farm laws, which would serve the interest of corporate capitalism. People's struggles for right to information, right to education, forest rights, social protection for homeless people, regulation of land acquisition, displacement and resettlement due to mega development projects. After that, my presentation was about the introduction to public policies and laws, and which explained the important features of public policies, its historical origin of different laws and policies, theoretical underpinnings of these public policies, and also difference between public policy and law and the interconnections between them. I also unpacked the dimensions of reservation policy, education policy, population policy, health policy, disaster policy, legislative provisions, and for all these policies, and which flow from Constitution of India. Dr. Shalu Nigam's presentation focused on history of human rights right from 1948 to the present. She explained global instruments, role of United Nations, legislative and judicial rules to public policies and laws. She gave several examples of successful efforts towards transformative policy intervention for social justice and gender equality. Today, now we have an important session by both Dr. Shalu Nigam and Dr. Vahida Nainar on international human rights. Over to the IMPRI team.
Thank you, ma'am. Sorry, am I audible?
Yeah, you are audible. Go ahead, Shweta. Your connection is breaking. Voice, video is fine. Audio is not coming properly.
Yeah, audio, it's cracking and echoing also in the.
Do you have an earphone? You can put the earphone, it will work fine. Nevertheless, we can invite our first speaker for the day. Shweta, go ahead.
Today, Advocate Dr. Shalu Nigam, fellow IMPRI, advocate, author, and gender and human rights. So, ma'am, taking session on multiple types of related perspectives. Over to Dr. Shalu.
Good morning to all of you. So, so today I will be talking about multiple legal perspectives, and here I just wanted to say that when I started working as a legal intern, and I, after studying, theories and other things, in the law college, when first time I went to the court, and at that point of time, Delhi has only 2 district courts. One is at Patiala House, which was dealing with criminal cases, and another was at Tisazari, which was dealing with the civil cases. And right now we have 6 district courts in Delhi, but at that point there was only 2. So and there was no metro, so I was taking a rickshaw to the court from the bus stand, and I asked the rickshawala that, okay, can you take me to this court? And then he asked me that, what is the meaning of court? Like he couldn't understand what the court is. So another person who was there present there, he said that you mean by kacheri. So, okay, I understand a new legal term, which is called, the court is also known in the legal, terms. It is known as kacheri if you talk about the street laws. So, the other thing, when I went for the legal aid seminars here and there, and people talk to me about kacheris and daroga and, those kind of legal terms, which was not taught in the law schools. So generally what is happening is, stuck here. The slide is not moving, sorry.
Now, bottom left, you can go to bottom left.
Yeah, okay. Yeah, so these are, when I talk about the term law, the different images which come to the minds of people is about, the judges, the lady with this balance, and or the prisons, or, the police station, or the handcuffs. But if you talk about the law in the textbooks or in the law classes, what they say is that law is about deterrence, about reducing crimes, or maintaining law and order. What this teach you is that governing law is about governing and regulating human behavior. And then they teach you about foreign, perspective, the Western perspective of law, which say, like, where various legal theorists have defined laws in their own terms. So say, for example, John Salmon talks about the law as administration of justice. John Austin says that law is the command of a sovereign backed by the threat of a sanction. Other scholars see law as organized political society. Some scholars talk about law as a combination of primary rules of obligation and secondary rules of recognition. Other scholars see the connection between law and customs, and they say that the law is a product of silent growth of custom. Other scholars, they define law as a social institution to satisfy social wants, and they see law as a social engineering tool, which means that law is an instrument to balance between the competing or conflicting interests. So basically, law is a system of rules and guidelines which are enforced through social institutions to govern human behavior. Another famous scholar, Ronald Dawkins, he described law as an interpretive concept to achieve justice. Other scholars define law as an authority to mediate people's interest. John Locke, another philosopher in West, he talks about law as a tool to enlarge freedom. For him, the law, where there is no law, there is no freedom. Another famous philosopher in law, the Kant theory, which many of, if you're a law student, you may be aware of. He is talking about law in terms of violation of rights. But if you talk about, some of the Eastern scholars or Eastern leaders, Mahatma Gandhi, he started the whole disobedience movement against unjust law. For Martin Luther, he said that unjust law should be broken, and so there is another perspective of law, which this people hold. So what perspective I am taking is that I am talking about law, about making an enforcement of law, because when I joined, and I'm privileged enough to join the civil society movement. I joined human rights movement. I could see the working of women's movement as a part of it. So here I will be talking about more about making an enforcement of law, where law is seen from a different perspective. So we are people from the human rights movement or the women's movement or other kinds of movement which are there in India about, the movements of the marginalized people. They're talking about law to regulate political activities, to regulate citizen-state relationships, to regulate economic activities, to regulate international relationship, to uphold fundamental rights and democratic ideals, to resolve issues such as starvation, unemployment, ending violence against women, and claiming rights by the marginalized groups. So I will start with two cases. We have already, mentioned. I have mentioned these two cases during my, last presentation. So one is again, which I learned from my association with the women's movement. So there is a struggle of Bhavri Devi. Second case I will take up today is about right to food, which is how right to food evolved in India. So coming first to the struggle of Bhavri Devi. Now she was. And how this struggle leads to formulation of sexual, the whole guidelines against sexual harassment, protecting women from sexual harassment at workplace. So Bhavri Devi she's from lower caste. She lives in Patel, Rajasthan, which is 55 kilometers from Jaipur, and most of the people in that village are from different high caste community. So she was married to Mohanlal Prajapat when she was around 5 or 6, and her husband was 8 or 9. And in 1985, she became a Sakin, a grassroots worker employed as a part of Women's Development Program run by Government of Rajasthan. In 1992, the state of Government of Rajasthan launched a campaign against child marriage. This campaign was ignored by the villagers and faced disapproval from the local leaders, including the village headmen. So one of the family of, from the higher caste, they planned to marry off their 9-month-old daughter, and Bhavri made attempt to persuade the family against carrying out their wedding plans. And on 5th of May, the day the TJ was celebrated, the DSP and the SDO, that is Deputy Superintendent of Police, they went to Pateri village to stop the marriage. They succeeded preventing the marriage from taking place that day, but the marriage took place at the 2 a.m. the next day, and no police action was taken then. But what happened is that Bhavri and her family, they faced social and economic boycott, and she was forced to leave her job while her husband was beaten up. On 22 September 1992, while she and her husband was working in the field, 5 men from the dominant and affluent caste from that village, they attacked her husband with sticks, leaving him unconscious, and gang raped Bhavri. In her complaint, she named 5 men. So in the police station, she was made to wait for so many hours, and police was not willing to write her first information report. So, and Bhavri was asked to deposit her lehenga as evidence. So she has to cover herself with her husband's blood-stained safa and walk 3 kilometers to the nearest village at about 1 a.m. in the night. This indifference continued at the primary health center, where the male doctor refused to medically examine her and referred her to the another hospital in Jaipur. But in his referral slip, he wrote that she was being sent for a test for confirming the age of the victim. The lab attendant at Jaipur refused to conduct tests without orders from the magistrate. The magistrate refused to keep the order until the next day, as it was past his working hours. So as a result, the vaginal swab was taken more than 48 hours after the rape, although the law requires that this should be done within 24 hours. Her scratches and bruises were not recorded, and her complaints of physical discomfort were ignored. So the state authority, as an employer, they refused to help her, saying that they were not responsible since she was assaulted in the fields. And the trial court, in its verdict on 15 November 1995, it dismissed the case and acquitted all the 5 accused. The accused were found not guilty because Bhavri husband, the judge says that the Bhavri husband couldn't have passively watched his wife being gang raped. And according to the judge, the village head and elderly could not rape. He says that the accused include an uncle-nephew pair, a middle-aged man from a village. He could not have participated in a gang rape in the presence of his own nephew. Then another argument he gave is that upper caste men cannot rape lower caste women because of the reasons of purity. So this judgment raised quite a outrage, and women's movement, they supported Bhavri, and by this pressure, the state filed an appeal to the higher court. But since then, her appeal has been heard only twice, and meanwhile, 2 accused have died. So, but meanwhile, a public interest litigation was filed in the Supreme Court, and as it's an NGO called Vishakha, they filed a case titled as Vishakha versus State of Rajasthan. And in August 1997, the Supreme Court gave the guidelines, and its decision famously known as Vishakha guidelines. Now, while giving these guidelines, the court considered the international conventions and norms because there were no such laws in India. There was no provision. So they considered international conventions and norms and also other articles in the Constitution, such as Article 14, 15, 19, and 21 of the Constitution, which is about right to life, equality, non-discrimination, and right to work. And they say that these guidelines are legally binding, and they define sexual harassment and impose 3 key obligations on institutions, which are relating to prohibition, prevention, and redress. So sexual harassment is defined as any act which is unwelcome, or behavior which is kind of the one such as physical contact or advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. So it was mandatory for all the establishment that employed 10 or more employees to appoint an internal complaint committee. The onus was held on the employer to establish such a mechanism, and the failure to set up these committees may attract fine up to ₹50,000. But during the survey, it was found that many of the organizations have not set up the internal complaint committee. Even many of the government departments, they also have not set up the internal complaint committees, and women were facing a lot of problems. And then again, women's movement, they become, actively, they say that, there should be a law, proper law. And then the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act was enacted after a lot of struggle in 2013. The act created a mechanism for redressal of complaints. It defines hostile work environment, for implementing the provisions relating to protection and prevention of violence against women. So the act formulated an internal complaint committee, and for the organizations which have less than 10 members, they say that there should be a local complaint committee. And they say it is the duty of the employer and the state to provide a safe working environment and to take steps to prevent harassment. And a lot of other things are mentioned in that. So so basically we have the law in a place now, but in terms of enforcement, what we are seeing today is that there are too many problems exist in the terms of enforcement at the level ranging from culture of violence with impunity, the approach of the state, rampant misogyny, the individual mindset that is sexist. So even this the current debate which is going about the wrestlers protest, so we all are witnessing that. So basically there are a lot of problems in enforcement, but But on the paper, this law is written in a very fine manner. But uh, so why this mindset is not changing, that we have to work on, because a survey was conducted in March 2022. So this survey asked the respondent that whether to improve the safety of women in the community, is it important to teach boys to respect all women or to teach girls to behave appropriately? So about half of us, 51% say that it is more important to teach boys to respect all women, but 26% says that it is more important to teach girls to behave appropriately. So how laws are implemented and enforced, that remains a big question. But now we have at least a law on paper. So this struggle of Bhavani Devi, though she could not get justice, but we got this sexual harassment law in 2013. Now, how to make this law more effective and efficient, that is the challenge before us. Now, second case which I want to talk to you about today is about the right to food. Why I'm talking about right to food? Because of my involvement with the human rights movement and the movements like UCL, where I saw that, you know, how the laws are being challenged, are being evolved, and these are not being taught to me in the law school. This is what I have learned because I have been associated with different kinds of movements. So this is the screen of World Food Program. It says that 21% of people in India are living on less than $2 per day. 1/4 of undernourished people in the world live in India. So food insecurity is persisting, and one of the recent survey which is being conducted by Public Health Foundation of India, they found that 10% of Indians have experienced food insecurity ranging from mild to moderate and severe categories. They conducted the survey with 9,000 adults living in Sonipat and Vizag, and they studied their dietary intake from October 2018 to February 2019. And one of the key findings of the studies, the effect of gender on the food insecurity. The women reported higher food insecurity than men. The study found that men, especially from rural areas, the people are consuming less of nutrient-rich foods such as dairy, fruits, vegetables, and non-vegetarian food. Even otherwise, the consumption of starchy staples was high, and intakes of legume and vitamin-rich fruits and vegetables was low. And they also found that women tend to prioritize food for their male members and children in the family. So the study also suggests that the wastage of food is high during the transportation, and from farm to plate, a lot of food is wasted, and therefore on the plate we are getting less of food, and therefore there is high food insecurity among people of India. And this is also confirmed by the Global Hunger Index, which ranked India to 107 out of 121 countries. So what is happening during the early 2000s, like the 47 people died in Rajasthan because of severe drought, while the lot of grains were rotting in the godowns of the Food Corporation of India. So PUCL filed a petition in 2001 and public interest litigation before the Supreme Court under Article 32, 21 and other provisions within the Constitution. And they say that there is a corruption in the public distribution system, and the distribution of foodstuff is irregular, and there is a lack of transparency in this distribution system. So the court says that, yeah, it lies well within Article 21, that is right to life with human dignity. And as a result, the court gave various interim decisions. These decisions are available on the internet, on the Google, you can search for it. But basically, the court says that India is a welfare state, and the state is duty bound to ensure that all the citizens get sufficient at least food to survive with dignity. And they said that government should ensure that the food is supplied through various schemes. So what are those schemes, such as employment insurance schemes, midday meal scheme, integrated child development schemes through Anganwadis, national benefit maternity schemes for below poverty line, the ladies who are there, the women who are there, national old age pension schemes for old people, and Annapurna schemes and various other schemes. And for the effective implementation of the orders passed, the court created commission, and on 8th May 2002 to hear the grievances of people related to food entitlement schemes. So it's basically, this part is important because the court, for the first time, it created commission to ensure that whatever the orders it was giving, it should be implemented. So commission, the job of commission was to ensure that all these schemes are being operated. On June 4, 2009, the President of India, the then President of India, he addressed the Parliament and announced that government should enact a new legislation called as National Food Security Act that will provide a legal framework so that food security is assured to every individual. So the primary act is focused on food, distribution of food grains through public distribution system, and that also ensure that preschool children are, they get proper nutrition for growth and development. And then a right to food campaign was created, and it raised the slogan "Bhuke Pet Bhare Godam," starving bellies, full godowns. So basically, the purpose is to ensure that the state do its work. So National Food Security Act was enacted in 2013. It converts legal entitlement for existing food security program, and under this law, the eldest adult female is recorded as the head of the household for the purpose of ration card. So it also includes midday meal schemes, integrated child development services, and other maternity entitlements, and midday meal schemes, and it provides subsidized grain to approximately 2/3 of population. Activists and academicians like Professor Upendra Bakshi, he commented that law and fundamental rights have been used as a tool by the activist group. And further, they say, Professor Bakshi says that in a sense, the new politics was broadly the constitutional politics. And even, this case went on for several, for maybe around 15-16 years. And now, since the act was created, the Supreme Court has stopped monitoring the provisions, the implementation of the law. But there are civil society members, there are academicians, there are NGOs who are still working on this law to ensure that people, enjoy this right to food. Even now, what they are finding is that they are doing surveys, and they are finding that there are a lot of gaps and challenges in enforcing these laws. So though the legal theorists, they draw on language of rights to argue for social change, but what is happening is that we have a long history of public distribution system, which is which started, which they say that there is a lot of corruption in that system. And scholars also claim that because of now this PDF system is linked with Aadhaar. Now, the scholar says that many citizens are denied benefit. And besides, there are other problems in implementing this law because the system excludes individuals who do not have a Aadhaar card, or sometimes the fingerprints doesn't match, and a lot of problems comes at the level of implementation just because Aadhaar card, that if you include this digital thing, because of that, people are unable to get the grains. So Also, the central government has imposed a state-wise numerical cap on PDS beneficiaries based on the data of census 2011, which is excluding many households. Then access to ration is denied in household where ration cards are not linked with Aadhaar, and it is leading to starvation deaths in several documented cases. Then often this law is being, the conservative attitude is deployed to interpret the provision of this law. And the activists on the ground are also fighting that in the terms of food which is being given through IMPRI or through midday meal, that food should be more protein-rich diet from diverse sources, including legumes, eggs, meat, milk, fish, and other kinds of food, and which is essential. And it's being denied in several states because of various reasons, including cultural or religious or the lack of funding. So what have we learned through these two cases? We have learned that law is not only the set of rules that operate in courtrooms or police station, but it has wider implication. It does not exist in vacuum, but law, morality, culture, and society are intertwined and interrelated in multiple and complex ways. Both the cases involve accountability of the state, where the state has failed at the moral level while denying justice and right to life with dignity to its citizens. Then social, economic, or civil and political rights are being denied, especially to the people who are living on margins. In both the cases, the women's, the Bhavi Devi struggle and the right to food. Now both are at the level of the fringes of margin, but they have to claim their citizenship rights, and their struggle was long and arduous and contentious, and it was a difficult process. So the actual realization of rights, especially by powerful and disenfranchised people, remains flawed and often bitterly contested. And therefore, we need, rights. These rights need to be constantly and continuously reframed, monitored, and enforced. So the complexity is involved in making and implementing the laws in a complicated society, but the social movements, the civil society organizations, they are expanding the idea of citizenship and working towards deepening of democracy. But while I was working on this aspects, there are several questions which I am putting to you, basically to the students. The Constitution of India defines India as a welfare state. So how these decisions are made to allocate resources, how these decisions are being taken by the government. What are the duties of state vis-a-vis citizens, especially those who are on margins? Why claiming citizenship entitlements become difficult for some people? Why in a society where Constitution promises equality and justice, different values are assigned to different lives? The state has resources, power, and capabilities to create appropriate conditions and to extend support to people who are poor, starving, who are destitute, people who are denied agency and freedom, people who are oppressed. But still, those people are forced to face unjust situations, humiliations, threat, or deprivations. Why violence against women persists and growing despite the existence of laws and policies on paper? Why the laws are not being followed in majority of the cases? Why the right to food or the right to shelter or health are not declared as a fundamental rights in the Indian Constitution? During the last lecture, we have talked about the right to education being shifted from the chapter on directive principles of state policy to the fundamental right section. But why, in terms of right to health, right to, shelter, they are still within, the directive principles of state policy. The courts are expanding the provisions under Article 21, right to life, and to declare these as the rights of citizens. But why the executive or the elected governments over the decades they have not considered these as their priorities. Now, last time somebody asked about, that capitalism, that, how should we counter capitalism? Now, people on the grounds, they are, challenging, they are, doing their best to fight for their rights. The thing is that we need to support them. We need to understand their problems. We need to find out, what is going on, and we need to support those kind of struggles. So with this, I would like to end my presentation here. I have with this, 2 sentences, that law is a site where marginalization is challenged and resisted by those who are subjugated. Yet on the one hand, law reinforces the patriarchal discourse, but on the other hand, it has authority to set out the social order. Women and marginalized groups have used law to challenge the hierarchy and dominant notions. Now it is up to us. What do we want to do? So now I will stop here and back to Shweta. Thank you. Thank you so much.
Thank you, ma'am, for such an enriching session and for sharing your valuable experience with us. I now request the chair, Professor Vibhuti ma'am, to share her remarks.
Thank you, Dr. Shalu Nigam, for a very, very lucid and erudite presentation. You also started with your personal experience as a new legal intern and how you negotiated your space and within the legal system. And I think your case study of Vishakha, especially Bhavri Devi's trials and tribulations and her experiences with the criminal justice system, you're very, very effectively shows that what kind of challenges we face. And your case study of even right to food, that how the PUCL versus Union of India's public interest litigation created discourses about this thing and expanded the scope and horizon of constitutional guarantees. I would like to add that even during the pandemic, whether it was a free distribution of menstrual pad or relief kit to this thing, or distribution of food packets, running of community kitchen, or discrimination faced by transgender people and sex workers. There also the legal activism of the civil society organizations, community-based organizations, and human rights organizations played a very important role. The whole presentation you concluded with that all of us people are fighting at the ground level. Okay, but we also need to, as professional, as a conscious citizen, we need to support them, and the solidarity is a very important mantra, even to make what is available in the law books, to make it practical experience. I think most important punchline of your lecture I found was that how law, morality, culture, tradition, and religion are related, and they also change, because we have seen in case of transgender persons, the whole section 377, it was the British rulers who came with that draconian law against the people who did not fit into the gender binary or heterosexual relationship. But with the people's participation, with the very serious legal discourses and the global pressure and the United Nations also coming up with the various covenants, I think we have been able to change. So it is this interaction is very important, and this democratic space is extremely important. Thank you very much for such an enlightening lecture.
Thank you, ma'am. Now the floor is open for questions from the audience.
Yeah.
Shweta, you can go ahead with your question.
Yeah.
Yes. Yes, ma'am. I wanted to ask about the role of technology in implementation of India's food security program, because there are at times when a lot of beneficiaries, there will be a misjudgment of beneficiaries of the program. So like we have Aadhaar card biometric systems and all the other technology. I wanted to know how exactly technology is streamlined in this program.
Yeah, so basically what the scholars, the activists on the ground, what they are saying is that, Aadhaar is the way it is being implemented, because earlier, because before Aadhaar, we have this bureaucratic structure, which is, huge and which is complicated and which is creating problem. And now the activists are saying that now this Aadhaar has replace that system, because our mindset has not changed, and still we are interpreting the laws, interpreting the provisions as per our old mindset. And they say that Aadhaar technology has created a lot of glitches in terms of, sometimes the system is not working. So if I go to, as a poor person, if I'm going to to the ration shop, and the shop owner may say, okay, your fingerprint is not matching, or the electricity is not there, you come tomorrow, so the poor people are need to run around and around the technology. So this way, and sometimes they say, okay, and sometimes old people, like their finger sometimes over the years, the fingerprints may they may be cuts or something, so that may not match with the official records, and then the persons are being denied, and a lot of deaths are being documented, starvations deaths are being documented, because people are being denied food and ration because of such kind of glitches. So what the activists are saying, that Aadhaar is creating a lot of glitches, the way it is being implemented, technology should have helped, and it has helped, because it has given us a lot of good things, like this web interaction we are having because of technology. But in some places, technology has created problem, and especially when it comes to the rights of marginalized, because you and I, we can afford, we can have access to easy access, and we can easily learn about it. But how can you say that the poor people on the street, for them it is very difficult to even operate a phone, or to even to get the phone in first place. So technology has created good things for some people, but at the other level, technology has created problems. So I think that is what we should be looking into.
I have a philosophical question here, that for certain things like a food or shelter or education or health, if you believe in universalization, there are countries poorer than us believe in universalization. Thailand has a universalization of health services. Cuba has a universalization of all basic needs. So from that point of view, can we have this kind of Aadhaar linked benefit, targeted beneficiary, this thing? Egypt has been giving pita bread for free. Okay, everybody. Rich people don't go. Those who have money, they don't go. But at least they have access. Anybody who is hungry can take this pita bread, which is sponsored by the state. Similarly, during Millennium Development Goals, several African countries, they started soup kitchens. There, nobody asks for your identity card, whether you are an African citizen or anybody who is hungry goes and have. So if we start that, we have our civilization, our country has reached a state that there is enough resources to do this thing. So yesterday, I think Mr. Chachra also told us about social cost benefit analysis. So if from the point of view of social cost benefit analysis, the amount of energy and resources that go for surveillance and monitoring, and who is qualified and who is not qualified into this, just one look at that person is hungry and famished and on the road, and that person deserves the state support. Isn't that for not only morally and in terms of human rights perspective, but even from the point of view of social cost benefit analysis, that why should we waste our resources in so much of surveillance and monitoring and deny people and lose such human resource, rather than focusing on being socially the social justice? And let us divert our energy. People are, because that's what Jan Mirdal had said way back in the 60s to Pandit Nehru, that investment in health and education and skill building is not an act of charity. It is a fundamental necessity of every country. So once you have a healthy people and healthy educated people, they will give you more productivity to the country. So I think we need to connect this with the larger long-term goals of the country. No? Thank you. Thank you, Shweta, for bringing out such an important question.
Good afternoon, ma'am. Good afternoon, everyone present.
Yeah.
I would like to ask one question, that during COVID, the migrant workers were being treated very badly. They were treated almost like animal, and we have learned in so many cases that mere animal existence is not existence. So, ma'am, any comments on that? That Article 21 was being invoked during that time.
Yes, when the migrants were walking, a lot of people were raising these kind of questions, that why, and the case went to the Supreme Court, and Supreme Court has given certain directions in state governments that you ensure that migrants get transportation, that the migrants get food. But then there was a lot of time has gone by the time the petition has been filed and heard and this order was given. So meanwhile, a lot of people have died, a lot of people have died walking on the road, a lot of women have given birth on the roads, so those kind of problems have happened. And, but yeah, surely we need to ensure more speedy decisions, more efficiency, more effectiveness, and that for that we need more of manpower and resources really, to deploy into this field. But what is happening at the state level is that the state is, putting human right defenders under surveillance instead of, helping people out. A lot of things are happening which shouldn't have been happened. So, these kind of things are happening. So it all depends, I think, on the political will and, the idea of the decision makers, and where and how they're investing resources. So that is something I think we need to work on, that how the state could be made accountable. And for that we have the movements like RTI, and other kind of mechanisms which are being put into place. But again, we need to have more of such movements where states should be made accountable for each and every action. And that is what the major demand of the civil society, for so many years.
Yeah.
So,
and I would like to add one more thing, that even the civil society organization, they also demanded from National Human Rights Commission to take suo motu action. So to speedify, because just not to depend on the court, because it will take long and it has its own process, but immediately looking at the situation, looking at the evidences available, audiovisual evidences, even civilians were taking videos, looking at that itself, NHRC was requested, and they finally, mainly, and the way mercilessly the migrant people were treated by police, the curfew, they were beaten up very mercilessly. So even violation of human rights, that was also being taken up by the civil society organization, and NHRC had to form 21-member committee with immediate. So that committee members were working in a different section of society, and they were rooted. So I think that was one very important initiative.
Thank you, ma'am. Thank you, everyone.
Yeah. Thank you, Surjan, for a very important question.
Shweta, we can go over to next session. Yeah.
Yeah.
Okay. Advocate Dr. Vahida Nainar, independent researcher, gender and human rights consultant. Ma'am, I would request Advocate Dr. Vahida Nainar to start a session on the topic of international human rights. Over to you, ma'am.
Thank you. Thank you very much. I will start sharing my screen. Just a moment. Is this visible? Yes.
Perfect.
Okay, perfect. Thank you very much. Yeah, I would really like to thank IMPRI and Professor Patel for having me as a person on this very important and impressive lineup of, as part of this impressive lineup of speakers on the Law and Public Policy Youth Fellowship Online National Summer School Program. Yeah, and the topics also going through the course outline sounds really, really interesting. Today, I am going to speak on international human rights law, application, impact, relevance, and I'm happy to be, going after Dr. Nigam, so I could refer to some of the, important cases and points that she also brought up and related to my talk. So, without further ado, let me begin. Here, in today's topic, we will be broadly covering 4 or 5 concepts. One is concepts of human rights and human rights law. I will talk about the various components that form international human rights law, as we know it. The application of human rights law, the impact of human rights law along with application, the challenges or the general trends that are that we see around on human rights today. They will talk a little bit about the continued relevance of international human rights law, and I'll give a couple of observations as part of my conclusion. So now talking on human rights and human rights law. I'm sure you've done this yesterday's session today, and some things you might feel repetitive, but nevertheless, as a matter of context, I will continue to, speak about it. Human rights in an abstract and philosophical sense is a special category of moral claim to dignity, equality that all human beings can invoke. The origin of human rights lie in the nature of people being humans themselves. See? Right cannot be given. They already belong to every single person. So every individual embody what is called human rights. But as we know, as we've just seen, the ground reality is that these rights that individuals embody can and are being taken away. Every day, and we see that around us, causing immense indignities and human suffering. So the contemporary notion of human rights originate from human suffering and exclusion by the society and the governing disposition of the time. So the notion of human rights is actually responding to the human suffering and introduces kind of new participatory contemporary notion of rights that those who have suffered embody, actually. So what we know today as human rights is actually coming out of the resistance and struggles of these movements and suffering masses, as we know. For example, the resistance against colonialism, in the early 19th century is what generated the principle of human rights, generally also, or the principle of of self-determination or autonomy. Similarly, the suffragist movement is, that was around that time, is what paved way for a convention on against gender discrimination. And various other rights that we know as human rights today are a result of the triumphs of these movements that transformed the moral claim of human rights to what we understand today as a contemporary human rights paradigm or framework. So that is broadly the human rights as a notion. Human rights law, on the other hand, is a manifestation of these rights or moral claims in positive law in the form of, for example, constitutional guarantees to hold government accountable under national legal processes. Human rights law is a more recent phenomenon that is closely associated with the rise of liberal democratic state. These, at the time, the rise of liberal democratic states, there were intense discussions around whether human rights are universal or are culturally relative, whether economic, social, and cultural rights should indeed be considered human rights or should prevail over civil and political ones, whether development should be considered a right, and whether or not, for example, one should name the states with a record of human rights violations. These were all the discussions that were that prevailed in the end. The global order, the world agreed on universality, interdependence, and indivisibility of human rights. This means that there are no hierarchy of rights, with some rights taking precedence over others, or that there are cultural or geographical exceptions. All human beings, wherever they live, have these rights and are entitled to have them protected and enforced. This is done by agreeing on rules governing society in the form of constitutionally entrenched and justiciable Bill of Rights containing human rights for all. Through this Bill of Rights, human right law is created, which then become part of the integral part of the legal system. Now, to move on to what broadly forms the components of international, what is known as international human rights law. These are four broad categories, could be categorized four broad systems. One is the charter-based systems, then you have the treaty-based systems, then you have the regional systems and the national system. The charter-based system arises out of Article 68 of the United Nations Charter, which set up the Commission of Human Rights. The main accomplishment of the commission was an elaboration and the near universal acceptance of three major human rights instruments: the Universal Declaration of Human Rights of 1948, then the two covenants, one on civil political right and one on economic, social, and cultural rights, both that came into being in 1966. The UDHR, the Universal Declaration of Human Rights, has given authoritative content to the vague reference of human rights in the UN Charter. And so whatever vague references were made in the UN Charter or known generally in the society as human rights was given a concrete form and an authoritative tone in the Universal Declaration of Human Rights as rights that every individual embody. So although it was adopted as a mere declaration and therefore not binding, it has subsequently come to be recognized as a universal yardstick of state conduct. And therefore it is an integral part of international law. The adoption of the separate two documents, that is on the civil and political rights and socioeconomic rights, indicate and was that the initial idea of putting Universal Declaration into a single binding instrument was not accomplished, because at that time there was, and I think still it does, that there was not very much an agreement about the justiciability of socioeconomic and cultural rights, the extent to which these can be quantified and implemented through law. And because of the lack of agreement over there, it has been split into two separate instruments. The charter-based instruments are applicable to all the member states of the United Nations. Then now coming to the treaty-based system. Treaty-based, the first treaty was adopted in 1965, and treaty-based system is something that moves the human rights, the whole document of human rights, from the more generic way that it is presented in the Universal Declaration of Human Rights to becoming more specific or focused on specific and marginalized and oppressed groups, or into themes. So there was a need felt to go into greater detail about the rights that have been already mentioned in the three covenants. So accordingly, the first treaty was adopted in 1965, which was the elimination of all forms of racial discrimination. So, and it was after this that actually the two covenants was passed in 1966. Similarly, subsequently, 9 other treaty focus groups or thematic treaties were passed. One was, some of these are the Convention on all forms of discrimination against women, or the CEDAW, or the Convention Against Torture passed in 1984, Convention on Rights of Child passed in 1989, Convention on all migrant workers on 1990. The last 2 conventions were passed. One was a convention on the persons of, with disabilities, and the Convention on protection from enforced disappearances. So unlike the charter-based system, only those states that have ratified or acceded to these treaties or aspects of these treaties are bound to observe these treaty-based only if they have specifically agreed. So it is not applicable to all the member states of the United Nations. Then the third is the regional system. 3 regional human rights regimes, which is the norms and institutions that are accepted as binding by states, have been established. These regional systems operate under the auspices of an intergovernmental organization or a regional political body. The first of such system is a European system, which is functions under the Council of Europe, which is formed to promote human rights and rule of law in 1949, followed by the post-World War II scenario, Europe. It adopted its primary human rights treaty, that is a European Convention of Human Rights and Fundamental Freedoms, in 1950, and includes mainly civil and political rights, but also provides the right to property. All Council of Members are parties to this European Convention on Human Rights. The second regional system is the Organization of American States, or the OAS, which was founded in 1948 to promote regional peace and security and development. The convention that the OAS adopted was the American Convention on Human Rights in 1969, which has been ratified by 35 states, so it is widely accepted there. The American Convention contains rights similar to those in the European Convention of Human Rights, but goes further by providing for a minimum of recognition of socioeconomic rights. In Africa, the human rights system, the human rights system was adopted under the auspices of the Organization of African Unity, which later transformed to the African Union. The charter adopted by the AU contains just some justifiable socioeconomic rights and elaborates on the duty and individuals and rights of all people. And all AU members are parties to this charter. But the way in which the principal regional treaty of the European Convention or the Inter-American Convention or the African Charter is implemented and enforced differs in each region. The European Court on Human Rights deals primarily with individual cases. A dual model is in place in the Americas, consisting of the Inter-American Commission of Human Rights, which is based in Washington, D.C., and the Inter-American Court of Human Rights, which is based in San Jose in Costa Rica. So individuals have to submit their grievances to the commission first, and then a case may proceed to the Inter-American Court. The commissions also has functions of conducting on-site visits, and the Africa, after some institutional reform, the African system resembles more with the Inter-American system. Then to move on to the national human rights regime, most of the member states of the United Nations have what is called the National Human Rights Commissions in their respective countries that perform similar functions as that of the treaty bodies of the United Nations, which we will look into in a few minutes, which means they take or they have the power to take suo motu cognizance of human rights violations. They do on-site visits to fact-finding missions. They prepare reports, present it to Parliament, and accepts individual complaints of human rights violations. India also, of course, have our National Human Rights Commission, which is set up under the Protection of Human Rights Act in 1993, and all the state human rights commissions that also implement or monitor the human rights situations. So that these are broadly the four components of the international human rights law regime. Now, moving on to what would call the application of international human rights law and its impact. It's the Human Rights Council within the United Nations that is the overseeing the monitoring and accountability of human rights mechanisms of the United Nations with regard to the Human Rights Treaty and the declarations. There are broadly three processes with regard to application of human rights, international human rights law. The first is what is called the Universal Periodic Review. This is a process that involves a review of human rights records of all United Nations member states. It's a state-driven process of the Human Rights Council, where each state declare what action they have taken to improve the human rights situations in their country and to fulfill their human rights obligation. It is designed to ensure equal treatment for every country when their human rights situation are assessed. The aim of this mechanism is to improve the human rights situation in all countries and address human rights violation wherever they occur. The next is what is called the treaty body committees. The human rights treaty bodies are committees of independent experts that monitor implementation of the core international human rights treaties, which I just listed in the previous slides. There are about 9-10 human rights treaty bodies composed of independent experts of recognized competence in human rights who are nominated and elected for a renewable term of 4 years by state parties. The function of treaty bodies are generally to consider state parties' report on the progress with regard to implementation of the treaty obligation, consider individual complaint, conduct country inquiries, adopt general comments, organize and clarify any treaty aspects of the treaties that are not clear, and therefore interpret the provision of treaties and to contribute to the treaties bodies strengthening process. So these are the functions of the treaty body committees. The next implementation or application procedure is what is called the special procedures. The special procedures of the Human Rights Council are independent human rights experts who report and advise on country situations or thematic issues in all parts of the world. They are not paid or on the rolls of the United Nations, but are elected for a 3-year mandate. There are currently 45 thematic and 14 country mandates. These are, when they call special procedure, they are basically either special representative or special rapporteurs on various thematic issues or on country matters. Now the thematic issues, 45 country, the thematic issues is wide ranging, ranging from rights like violence, special rapporteurs on violence against women, on indigenous peoples, on coercive measures, on trafficking, involuntary disappearances, and so on and so forth. And what is important in giving equal importance to the civil and political, the socio and economic rights, there are several special procedures established on these, such as on water and sanitation, special rapporteur on development, poverty, housing, health, food, environment, education. So the special procedure has laid to rest any disagreements or contentions about the hierarchy between civil and political rights vis-a-vis the socio-economic rights. And the 14 country mandates include countries like Russia, a special rapporteur on Russia, Somalia, Eritrea, Myanmar, etc. These special procedures operate under the Human Rights Council. They make country visits, they act on complaints of individual cases of human rights violation by sending communications to the state concerned. They engage in advocacy, public awareness, and general promotion of the human rights standard. In terms of impact or impact of international human rights law, in the United Human Rights System is primarily achieved through the processes that I just listed, that is the Universal Periodic Review, special rapporteurs and experts who investigate and publish reports, the treaty body complaints that the treaty body committees receive, or individual complaints, and this has been a useful and part and impact of the human rights protection regime of the United Nations. Some of its direct impacts are the contribution to the fall of apartheid in South Africa, human rights components of peacekeeping missions in conflict countries ranging from El Salvador to East Timor, the establishment of ad hoc criminal tribunals or partly criminal tribunals for the former Yugoslavia, Rwanda, and Sierra Leone example. These are the direct impact and successful intervention on individual case by rapporteurs and treaty committees. So these form the direct impact of these human rights, international human rights protection regime. But beyond this, the direct impact has been quite modest. To the contrary, the direct impact has been greatest in Europe, where the European Court of Human Rights have not only awarded damages to individual plaintiffs, but the European governments have revised legislations on several human rights matter and sensitive matters like media criticism of judicial proceedings, national security measures against terrorists, gay rights, family rights, women's rights, and criminal justice procedures. The second is the other rulings of the American Convention American Convention on Human Rights, where the Inter-American Court has delivered several awards, significant damage awards against states for violation of right to life. Governments also began to accept substantial damage awards in settlement negotiation with the Inter-American Commissions. In addition, national courts in Latin America have begun to follow the jurisprudence of Inter-American courts in rights cases, and which has resulted in modification of national laws. And the Inter-American human rights legal system has consolidated almost all the nations in Latin America except Cuba, who accept the binding contentious jurisdiction of the Inter-American Court. So these are the direct kind of impact. Indirectly, so the impact of the international human rights regime is most seen in the indirect impact rather than the direct ones, which is interventions that protects rights by reinforcing public awareness, exposing violations, bringing it into documenting violations, advocacy against the state that is perpetuating these violations, legitimizing efforts of the non-governmental and civil society organizations, and keeping the human rights agenda alive on diplomatic, tables. This kind of indirect impact is a contribution of several stakeholders, not only governments or the United Nations or the government participating through it, but also the communities of like-minded rights advocates in non-governmental groups, whether they are international, regional, national, non-governmental groups, academia, media, who work together across national, transnational, professional boundaries to promote the shared values of human rights and agenda. So what has this done indirectly is that it has significantly contributed to the growth of human rights consciousness around the world. So on all the processes, the application processes that I have talked about of the international human rights law, that is the UPR, the treaty making, the national regional bodies or national bodies, are all interrelated, greatly interrelated. It is the human rights groups, for example, that makes constant use of human rights, international human rights law in their organizing and advocacy. It is through the advocacy and the movements in the ground that these laws and the rights are articulated at the movement level, which then is taken on by human rights groups and in their organizing and advocacy at the international regional level to articulate these as in legal language in the treaties, treaties and conventions, and which then becomes international law, and then again used in turn by the same rights organization in their advocacy to implement these laws. National human rights ombudsmen regularly appeal to international norms and laws in opposing any state efforts or local efforts to legislate lower standards nationally. Constitutional courts increasingly look to international treaties and jurisprudence of international courts in interpreting national constitutional rights. We have seen, as you know, that Dr. Nigam just spoke before me, of how, because there was no law in the cases that in the Vishakha judgment case, the courts referred to international law in making its guidelines. So, so national and international debate keep alive and advocate for effective treaty language for its implementation at national, regional, and international level. The other place where I could think where this is also courts have dependent on international human rights law is in India, the case about torture. There is no specific law mention of torture in prohibition of torture in the Constitution, or a specific separate law on torture in the criminal system. Nevertheless, that doesn't mean that this is not prohibited in torture. Courts have prohibited torture in their jurisprudence by referring to the Torture Convention internationally and reading this prohibition of torture within the existing provisions of the Constitution. Now, to move on to some of the current trends on human rights or the challenges. So what is there in terms of human human rights law? In practice, as we have seen, always a gap between what is written and what we see around us. The treaty-based or the international human rights law is often treated and considered in practice as lower in priority to several different things. One is to customary practices. Several countries have made reservations to treaty clause and opt out of adhering to it or citing contrary customary or religious practices and law. In India ourselves, we have accepted, acceded to, and ratified the CEDAW Convention, but have made reservation to the place that talks about customary law and has opted out of obligation to be bound by those provisions if it runs contrary to the religious or customary laws in India. It is also treated lower to national, considered lower, of course, to national laws, and several national laws are contrary to the international human rights law provision. Several countries have laws that allow for death sentences that goes against the commitment for human rights. Same is the practice, for example, of extrajudicial killings or extrajudicial torture that happens within the national systems. Or also treaty often human rights is treated in practice as lower to religious laws and practices. And because these often justify discriminatory treatment to women and other marginalized groups, which then is upheld over the human rights law. So the current trends worldwide is that is of human rights law that is backsliding and being undermined, watered down, both in its application and its protection or its obligation to protect and promote it. And these are for several reasons. The rise in authoritarian governments, for example, several governments have seen rise in authoritarian or autocratic governments. The hallmark of such government is the undermining of civil liberties, the illegal detention of governmental and civil society opposition, the undermining of marginal communities, and use of state institutions to achieve all these, undermining of civil liberties and other acts. The other is the divisive nationalistic rhetoric and identity-based majoritarianism, which continues to undermine and actually chip into the trust between communities and contributes to widespread harassment, discrimination, and violence against women, children, persons with disabilities, marginalized communities, whether they are marginalized ethnic communities, minority communities, linguistic communities, gender and sexual minorities. Often it is distressing that these groups often lack adequate legal anti-discrimination remedies within the national legal system. And wherever the such remedies exist, the implementation often lags behind. Similarly, traditional values also fuel negative stereotypes and harmful practices and are used as justification for violation of human rights. Women remain subject to discrimination and violence and are denied access to opportunities, economic and other resources, both through active and passive discrimination. And then is, of course, the shrinking civic space. Civil society organizations are facing increasingly restrictive laws and regulations for their registration, access to funding, participation in public affairs. Human rights defenders receive threat and attacks in both online and offline space for their legitimate human rights defense action, often without accountability of their perpetrators. Those who voice the rights of women, ethnic minorities, or gender minorities, migrant refugees, or those who work on anti-corruption measures, environmental rights, and investigative journalists, or opposition of the government's extreme right agenda, are especially under attack and increasingly under threat these days. Either they are under detention or they're under surveillance, and all kinds of regressive measures are imposed against human rights defenders. So, that being the situation, do any of these challenges in any way diminish or undercut the relevance of international human rights law? Law is a question. But how and why do they continue to remain relevant is something that we would look at now. Is the continued relevance of international human rights law is for several reasons that we have, that actually summarizes what we have been talking in terms of its application in language. But there are broadly few points that indicate the continued relevance and importance of international human rights law. One is that it provides common language. The rights groups anywhere in the world can invoke the same set of rights expressed in the same language, interpreted in the same way by either human bodies, regional bodies, national commissions, or courts. The second is the universality of human rights. There is no question anymore about whether there is these rights has exceptions with regard to any geographical region or culture. With 3/4 or more governments having accepted the main human rights treaty, the universality of human rights is enforced. It endorses the fundamental nature of these rights and strengthens acceptance on domestic and political debates. The third is it legitimizes claims of rights. Because these rights are widely accepted by governments within national law, they confer legitimacy when rights group, an advocacy group, asserts their rights against their governments to hold them accountable to what they have themselves declared and accepted as parties to the treaties. Next, it indicates the will of international community. When the treaties and the rights are have broad participation by governments, it is not just they accede to the rights, but they have followed a formally serious process of negotiation of language in these treaties, the ratification of the treaties, international human rights treaties. It is often perceived as a will expressing the will of international community that governments find it increasingly to formally negate or backtrack from. Elaboration of the rights language. Whether international human rights law is put in treaty form, the rights are elaborated in all its dimensions and legal precision, which is often lacking in political declaration and philosophical pronouncement. It incorporates not just the right, but the various aspects of these rights in a legal document and give it a certain authority. Then there is an expectation of compliance. Because these human rights has gained the authority of international law, it generates increased expectation of compliance and narrows the differences available to violators. States often deny that violations were committed, but they cannot easily deny their obligation to respect the relevant norm. A government may have well accepted an international obligation with no intention to comply, but this is a difficult thing to admit publicly. The government may find itself trapped by its own hypocrisy. Then there is domestic judicial enforcement. Treaty-based human rights law encourages domestic judicial enforcement, while non-legal documents do not. Many constitutions expressly incorporate human rights as fundamental rights or read such rights into the meaning of word already in the constitution. So in India, for example, several socioeconomic rights, like we mentioned, the right to food, the right to education, the right to housing, or being free from torture, is read into the all-encompassing Article 21, which is the right to life, which is to say that if you want to have a life of dignity, you need to have all access to all the other socioeconomic rights as well. Then you have the international enforcement of rights. In international courts or agencies, is increasingly growing in practice in Europe, Americas, and other international human rights commission. The threat or the perception of its potential gives human rights groups added leverage and makes governments nervous. The uncertainty is aggravated by the trend towards increasingly enforcement in new and unexpected ways. For example, the arrest of Chile's General Pinochet on Spanish arrest warrant in London, or the denial of credit by World Bank on human rights ground, which they earlier kept denying that the bank could not consider human rights, but through the practice of indirect impact, World Bank is now forced to include human rights records as well. And then, of course, there is additional stigma. Human rights law and its violation generate broad condemnation on moral grounds alone. Even so, in many cultures, including a culture of international diplomacy, criminal conduct carries its own additional stigma, undermining the capacity of violators to defend their conduct while enhancing the force of condemnation. And finally, and I believe importantly, it has no scope for any kind of moral relativism. The state violence does not always provoke moral outrage. For example, populations victimized by opposing ethnic or rebel group may tolerate or indeed applaud brutal retaliation, in the form of violence by state or other actors. Yet in such situation, international law, which is written for universal application, potentially keeps its bearing and serves as the conscience keeper. For example, in Peru, very few people actually protested the prison massacre of Shining Path guerrillas, whereas in the Inter-American courts rightly ruled against Peru's resort to excessive force against the guerrillas in the prison. Similarly, when the Israeli Knesset failed to stop torture of Palestinian security suspects, the Israeli Supreme Court finally ended the practice based on the language of human rights and the universality of it. So while governments around the world may selectively, protest assassinating of security suspects, or what they call terrorists, rights groups, international rights group, rightly denounce these violations of international law. So where moral clarity may be lost in the passion of the moment, international law can not only condemn, but also teach, helping morality to regain its compass. So those are the broad points that continues its relevance with relevance of international human rights law. So in conclusion, a couple of points would state that the issue is not whether international human rights law achieves its lofty objectives entirely or comes even close. It is rather whether it's a useful tool for human rights protection activities carried out by governments, non-governmental organizations, press, media, court. Plainly, the users of human rights tools, that is the activists, advocates, journalists, ombudsmen, human rights litigators, testify worldwide to the importance and the regular use of these human rights law and instruments, and they testify to be of immense value in their efforts of advocacy nationally and locally. And finally, the relevance of international human rights law could be assessed by assuming its absence. Without international human rights law, that is only with national or international philosophical declaration, it would be difficult to imagine existence of a human rights regime with a comparable degree of universality in language, in application, in legitimacy, universal legitimacy, and precision in the human rights norm, and of the stigma and the risk of potential sanction for its violation. And with that, I'll conclude, and I look forward to the conversation. Thank you very much.
Thank you, ma'am, for such an insightful and very enriching session. I request the chair, Professor Vibhuti, ma'am, to share her remarks. Sorry, ma'am, to interrupt. You are on mute.
Yeah. Thank you, Dr. Vahida Nainar, for making such an exhaustive presentation right from the time of Second World War, where the Bretton Woods institutions came up and they were established. And you also told us about the whole various generations of human rights, three approaches, whether it's treaty-based or charter-based, or regional human rights and national human rights. And you also said that with all the limitations that we are facing due to authoritarian regimes not giving us enough democratic space, human rights, international human rights are extremely important, and they have their relevance in current context. And what I would like to add is that, yes, you gave example of Peru, Latin America, and you also, but I think at the same time in Asia also, we had an example in Cambodia, what the Pol Pot did and what the international bodies or International Criminal Court. I think even for that, on that, if you can throw some light, the role of International Criminal Court. And also currently what's happening in Ukraine and the polarization of public opinion that has taken place globally. So I think political structures, political trends, and the international human rights regime and the provisions that we are given, how they are, what are the dynamics that so many times the power relation that you have with the political regime and the international human rights instruments. Can you just throw some light on this aspect, and especially the role of International Criminal Court?
Okay, thank you very much for the question. Yes, I was imagined that they would this question on Asia would come up in the conversation. As we know, there is no similar or comparable regional regime with regard to human rights in the manner that there is in the Europe, Inter-America, or Africa. Several efforts were made, and there are continuing conversation, but none of them has gained any kind of momentum, because in the human rights movement history, particularly with regard to particularly with regard to the UN space, United Nations space, the countries in Asia have been the most resistant with regard to a complete universal acceptance of the human rights norms. And that resistance and lack of acceptance is shown in the disagreement or non-agreement with regard to having a human rights regime comparable to the European American, Inter-American, or African regime. So that's one part. Of course, as you pointed out, there continues to be widespread human rights violation in the region, and some of it has been addressed mostly by civil society organizations and the United Nations coming in and intervening with regard to establishing some sort of intergovernmental, not entirely a UN system for the Cambodia violation that happened during the Pol Pot regime in the 50s and 60s. So but most of the human rights accountability mechanisms that have been seen in Asia had been from international and regional human rights civil society organization. Yeah. There was a public hearing organized within the Cambodian system that was initiated by the Defenders Project Cambodia, which got the survivors who are very old to come and talk about the violation they experienced during the Pol Pot regime, and documented their experience in a way and gave them gave a certain summarized place these experiences within the human rights law regime, which then formed the basis for having a formal process of the which is a national international semi structure court called the extrajudicial court of the Cambodia, court in Cambodia, where the national judges, Supreme Court judges are also part of the same court, looking into the violations during the Pol Pot regime. And the ones that the civil society organized a public hearing, which gave a lot of documentation that to the court and the prosecutors there was done by the civil society organization there, and I was part of the jury member of that particular public hearing that gave that ruling about the need to look into these violations within the court systems of Cambodia. And the other example I can provide within Asia was the Women's International War Crimes Tribunal on the former comfort women, which again is a international regional effort by women's groups in the countries affected by the comfort women system of the Second World War, where all these civil society of these countries, these include, of course, Japan, but Indonesia, Philippines, South Korea, and Netherlands, who came together and hold the Japanese government accountable for the crimes that happened against the former comfort women, documenting the experiences of now of the former comfort women who were at the time in the year 2000 around 80, 90 years old and living in shelters for former comfort women. So those have been the other informal accountability mechanisms, but these done by civil societies. These also used and relied heavily on the international human rights norms and language for getting that accountability. The next one would be to talk about the dynamics of power relations. Yes, in terms of what gets formally held accountable or no, or not, what kind of violations around the world get formally moved to the international spaces like International Criminal Court, or and what does not, is entirely in a political discussion that is taken at the Security Council level, where there is intense power dynamics. So while most of the cases that we see in the International Criminal Court is of violations that has happened in the African continent, it would be very hard to argue similar kind of accountability for any kind of the massive human rights violations that have been come out as a result of actions of the United States because of the power relations that they hold. The same kind of power relations and the power dynamics in the international body is at play in the current Russia-Ukraine war as well, and what gets condemned as human rights violation, and the rights of Ukraine to its self-determination, or what Russia does. All these discussion is heavily kind of influenced by power dynamics. And the more powerful that the country is, particularly the ones with the veto power in the Security Council, can get their way with regard to what they get in terms of violation, not only of their own citizens, but of other territories. So the power dynamics definitely is there. And I would, if I were to take a guess, I would think that it would be exceedingly difficult to, for example, haul Russia to the International Criminal Court for violations it commits in Ukraine, the current ongoing war. And this will unfold as the consensus of the world, changes and more information comes out. This will be informed in the years to come and how that changes. Yeah, I think I'll conclude that over there. And we can take other questions.
The floor is open for questions from the audience. Ma'am, I have a question.
Sure.
My question is how the standards under the international human rights law address challenges, emerging challenges like, for example, the climate change or data privacy, data protection issues. How are these addressed while maintaining the universality of the international human rights law? Because my understanding is that international human rights are universal and at times even non-negotiable, like the right to life or freedom to express or speech. So how do these concerns get addressed per se while maintaining universality is my question.
Yeah, thank you. I think the answer to this question is in your question itself. What you mentioned in terms of the universality of human rights. When you stick to that universality and the indivisibility, you cannot undercut human rights, or you can say accept one aspect of it and not accept the other, or you make it conditional based on any of this, on any factor. If you keep that as the basis of you, that is the only way you can address the current challenges, whether they are of climate change, whether they are of data protection or the privacy and all of that. Because all of that would be measured with regard to the extent to which it violates or do not violate these fundamental norms. So climate change, if there is anything, any change or any kind of policy that, for example, violates right to life or prevents peoples around the world from getting the fundamental socio-economic rights, which are basic, which are universal, which are indivisible, then those states are in violation of these rights. And these arguments that some countries kind of put forward against, for example, when they are held accountable for any kind of, carbon emission, to say that these concerns are coming from countries who are already developed and they are the reasons why they do that is to prevent our countries from developing is a short-sighted argument, and it's an argument that completely undermines and the human rights are in violation of human rights now. Because these emissions, if they eventually deprive people of their livelihoods, if they, are responsible for ocean levels and sea levels rising, wiping out entire villages, then these are directly violating human rights, basic fundamental human rights. Similarly, data privacy issues. If you are constantly under the public care, if you have no right to privacy, which is an integral part to right to life, then these are the only way these concerns can be addressed, that is to put these human rights law as fundamental as our basics against which every kind of concerns is measured. And then you call out the violators, and then you find ways as to how to address these issues in your discussion on climate change or infringement on data and privacy laws and so on.
Thank you.
Thank you.
Now I request Professor Vibhuti ma'am to give her closing remarks for the session.
Yeah, dear participants, today we had a very rewarding session because it started with the first-hand experience of Dr. Shalu Nigam in the legal system, and she's a practicing lawyer. And she also started with the two very important case studies that she provided was the Babri Devi struggle and the Vishaka directive, and also the question of right to food campaign and how the state and non-state actors, they played an important role in expanding the horizons of human rights. The second presentation by Dr. Vahida Nainar, which talked about the international human rights regime and various approaches that the global community has adopted and what we have attained and where are we, the whole dynamics of political structures and the political social movements, international organizations, civil societies, international organizations, and the nation states, how are they responding to this international human rights. And slowly and gradually, as the public education, people's sensitivity towards these issues increases, even our attitude to certain measures taken by the state changes. For example, what happened in Bosnia or what happened in Somalia, or the ethnic cleansing which took place in several African countries. When it happened, the community world community took time to take its stand. But in course of time, when more data came out, international bodies, they started organizing public discourses, then the people's understanding changed. Her example of Chile or recently, and then later on, she spoke about the experiences in Asian regime, even the comfort women, those who were forced to do to entertain the soldiers during First and Second World War. And now world community took nearly 60, 70 years to make the guilty party apologize to those women. So I think there is a hope. Like, main thing is that things are difficult, but there is a hope if we all educate ourselves, take stands, stick out our neck, and also build public opinion within wherever we are, whichever institution, whichever regional location we are in, we can create this kind of consensus. And current challenge that we are facing in Iran, in Afghanistan, in dealing with the drug cartel, and also the climate, how to make the consumerist society responsible towards climate justice. I think it's very important, and the most important overarching concern that we have is a sustainable development goal. What are we going to leave for the future generation? I think that is a major challenge, and these human rights instruments, they aid and deepen the discourse on these challenging issues. Thank you very much.
Thank you, ma'am. With the permission of the chair, we can go for vote of thanks.
Yes, yeah. Please go ahead, Shweta, with vote of thanks. Yeah.
As we come to the end of day 2 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course, and internship program, I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the day 2 session, Advocate Dr. Shalu Nigam and Advocate Dr. Vahida Nainar, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you this Friday, that is 16th June at 11:30 a.m. for our 3rd day of this certification course by distinguished experts, Professor Mukul Ashar and Advocate Dr. Shalu Nigam. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to our IMPRI #WebPolicyTalk and #WebPolicyLearning. Wishing you a good day. Thank you.